Hello, everyone, and thank you for coming to today's webinar on values-based contracting for grantmakers. James, you can go ahead and go to the next slide. Today's session is part of a series of events that Rockefeller Philanthropy Advisors is doing in honor of our 20 years helping donors create thoughtful and effective philanthropy. We are planning several events on all aspects of philanthropy over the coming months. And the next two, which many of you have already signed up for, are noted on the slide, and those will be on navigating grants, supporting advocacy to C3 and C4 organizations, and separately cross-border grant making, due diligence, and legal considerations for global grant making. This session that we're in today will cover contract basics. So it is a kind of a 101 on contracting, but there will be plenty of opportunity for questions on more specific scenarios. Now, I have to give a required disclaimer that this is not legal advice that would require a different kind of relationship. This is really just informational and a chance for you to get some general guidance that we would recommend that you take to your own attorney if you need to. Finally, I want to request that everyone who's here, please provide feedback by taking the survey at the end. You'll get it through an email. Now, in terms of some logistics, there is a question and answer place to ask those, and we ask that you provide as many questions as you want. We're going to try to cover as many as we can throughout the presentation as well as at the end. And I also want to note that this session is being recorded, so you will be able to get the recording afterward as well. We'll send it out to everyone who registered with their email address. So I am thrilled to welcome today Nick Campbell. Nick has more than 15 years of experience designing and building nonprofit organizations from the concept phase to the full independence, as well as designing innovative organizational, grant making, and governance structures. She worked as Senior Director of Operations and Foundation Counsel for Dalio Philanthropies. She was Deputy General Counsel and Secretary for the Open Society Foundations, and she worked as Associate General Counsel for the New York Community Trust. In addition to serving as Rockefeller Philanthropy Advisors General Counsel, Nick is also the founder of Build Up Companies, which is a federated group of companies comprised of Build Up Advisory Group, the Campbell Law Firm, and Build Up Inc., which are focused on transforming outcomes for vulnerable and marginalized communities. She also has a weekly podcast, Nonprofit Build Up, as well as a newsletter for on infrastructure for grantmakers. So Nick is a very busy person. So we're thrilled that she's able to join us today for the webinar. And with that, let's go ahead and get started. So Nick, I know that you prepared some slides for us, so let's get started with what we're talking about here in terms of what is a contract.
Yeah, sure. Thanks so much, Renee. And hi, everyone. I am really looking forward to this conversation because we're talking about values-based contracting. And I don't think that kind of conversation happens frequently. I think as grant makers, we spend a lot of time thinking about our values, talking about our mission, our vision, and making sure that it's clear internally and externally. And then separately, we have conversations about our legal agreements. Are they protecting the organization? Are they really representative of the kind of risk management approach that we want the organization to have? But it's very rare that you have those conversations happening at the same time in the same room with the same group of people. And so that's what's going to happen here. We're talking legal agreements and the fundamentals within them, but we're also talking about values within our organizations and how do those values show up in our contracts. So just to get us started, we're using that term contract. What do we really mean? And when we say contract, it's really an agreement between two or more persons to do something. That's it. That's a contract. And you'll note that we didn't say a written agreement. We didn't say a verbal agreement. It can be either. You can have an agreement between two or more people, two or more organizations to do something. And you probably have heard of verbal contracts. If you watch any of the court shows, they're usually in court because they say, look, we had a verbal agreement, we had a verbal contract to do this thing. So there are some states within the United States that do not allow verbal contracts to be enforced over a certain dollar amount. So there's some limitations when you agree verbally to do something and you don't then reduce it to writing. So our position is, if it's important enough to agree to it verbally, and you are agreeing to do something with someone else or with other persons, and we'll talk about what persons mean in this context, then it's important enough to put in writing. So this entire conversation today, we'll be talking about written contracts, written agreements. And we use the word persons as opposed to people because you can enter into a contract between an individual and an organization or two organizations. So we use the term persons to encompass all of that. So that's what we mean when we say contract. What you might be thinking of when you hear that term, if you're a grant maker and you're in a grant making organization, is a service agreement. So consulting agreements, vendor agreements, you might be thinking only of service agreements. That's just one type of contract. There's also grant agreements. So all of the awards that you're making to organizations or to individuals for their grant work will be covered with a grant agreement. And if you make changes to either of these, you'll be doing what we call an amendment. And again, remember, with amendments, they could be in writing or they can be verbal. Again, we're talking about an agreement. And so we'll really emphasize that we want amendments to be in writing. It's very important that they are in writing because you are changing the terms of a written agreement, right, in this case. So these are the types of contracts that we will be focused on today. And we know that there are many others, right? But we're just giving the examples of agreements that come up in the context of the work that we're doing.
So I think we have a poll that we'd like people to take now in terms of what kinds of agreements they are most concerned with. So take a minute to answer those questions. You can choose multiple ones if you like. And Nick, while people are answering that question, what are the most common types of contracts you see grant makers enter into outside of the grantee agreements, which of course they all do?
Definitely a lot of consulting agreements. We see a lot of those. And we also see a lot of vendor agreements. So if you're not engaging someone to provide a particular service for you in the consulting context, you might be engaging, an IT provider, for example, or a communications provider. And so you might do those through vendor agreements. So we see a lot of those.
Okay, great. And then you mentioned that it is your preference that all agreements be in writing, particularly amendments. What kinds of agreements don't rise to the work needed in order to have a true contract, if any, in your view?
So I would say that if you don't care about the outcome, then, if the person does it, great. And if they don't, oh, well, then that's the kind of agreement that you would want to leave as a verbal agreement. So I do think that you should put all agreements in writing, and the writing doesn't have to be like the kinds of templates that we're talking about today. It could be an email, for example, where you just have an agreement in writing and it's clear who's supposed to be doing what.
Mm-hmm. Great.
Okay.
And it looks like we have the results from the poll. So
Yes.
81% are most concerned with grant agreements, and then strategic partnership agreements, which can be a lot of different things, really. They can be collaboration, they can be a true partnership of equals, they can be a partnership of pretend equals, where one party doesn't realize the power that they have over another party. So is that in line with what you see in your practice?
Definitely. So I see a lot of grant agreements, definitely consulting agreements, as I mentioned, and I've been seeing more recently an increased number of partnership agreements. So we see MOUs coming into play a lot more. We also seeing just like how parties being very interested in stating how exactly they will work with each other and being very deliberate about that. So this is all resonating with me and the work that we do.
So while we're talking about partnership, I know that one of the things that we really wanted to talk about today was how contracts can help build relationships.
Yes, definitely.
So let's go on to the next slide. And great.
So we talked about these conversations that are happening in different rooms, right? You're having these conversations about values of the organization. In another room, you're talking about legal agreements and risk management. And our position is really that contracts are not just a legal document that comes out of nowhere after you have done the relationship building. Contracts are, in fact, relationship builders. The way that you want to show up with your partners, with your grantees, you will be having those conversations. I find that a lot of organizations spend a lot of time talking in the beginning of the relationship about this is how we work, these are our values, this is how we want to show up, this is how we want to partner. And then when we get to the legal agreement, it's a legal document that comes out of nowhere. It's full of legalese. Many parties don't understand it, and they just see it as, oh, we just have to get that done. In fact, if we shift our mindset and think about contracts as actually part of that relationship and part of that relationship building, I think that that's the real key to this entire conversation. So if there's anything that you walk away with today, is just to shift that mindset to see contracts as key relationship builders. Why? They help to build trust, to keep that trust going. Whatever you've been saying up until that point, the partner, the grantee should be able to see those same commitments, expectations sitting in writing before them. Right. So it should be another way to say you can trust us and we can trust you to do exactly what we said we were going to do. Expectations, we're managing, we're setting expectations within this document. And so it's another way to say, this is how our relationship will work. Here's what I expect of you. Here's what you can expect of me. And you can negotiate what those expectations are. And then finally, care. And this is not a word that you normally associate with contracts, but this is the way that you will care for the work that's being done and care for each other within that relationship, right? So just taking a step back and saying, what is this contract doing? Is it contributing to this relationship building, or is it helping to sort of dissolve the relationship or weaken the relationship that I've started to build? And that's how we want to make sure that contracts are being seen and used within your organization.
Great. So we had a question about the one of the comments that you made about if you don't care about the outcome, then don't do a contract. But there are scenarios where you do care about the outcome, but you may not want to bother to do a contract agreement because there's no recourse if the terms aren't abided by, right? So we wouldn't, why should someone do an MOU or some kind of contract agreement if there's no recourse?
So there are a couple of reasons to do a contract. So part of it is, the legal piece, which is, if something goes wrong or if there's a breach, then you can follow up, you can take it to court, you can, try to resolve what's happening legally. The other piece is just to say, this is how we will work together. Here's my understanding of our relationship, and the other party can say, here's our understanding of the relationship. And it's at least very clear there, this is what we're expecting of each other. And so I think apart from the legal implications of whether or not you'd be able to enforce something, it's about how will you work together? Do you know what's expected of you? Can you actually show up and be a good partner? And so all of those things matter. And if it matters enough to have the conversation about it, it should matter enough to, again, put it in writing. And it doesn't have to be an elaborate writing. When people hear contract, I think they think, oh my goodness, this is going to be 10 pages long. It's going to be full of legalese and I just can't do it. A contract can be an email between two parties where one person says, I think this is how we should be working together. This is my agreement. The other person says, yes, this works. Or I want to also add this piece, and both parties confirm via email. That's a contract, right? So just know that there are a spectrum of how contracts can show up. And we'll talk about what contract templates can and should do, and how you should be looking at those templates. But my position is that if it's important enough for you to agree to it verbally, and you do care about the outcome and the way you're working with the other person, put it in writing and make it a written agreement.
So it helps the rigor of going through the writing process and the documentation process. It sounds like it helps to really clarify the relationship and expectations, and perhaps even uncover some underlying assumptions that people don't even know that they're making. And so I guess hopefully that answered the person's question about it doesn't have to be a formal contract with all of the provisions we're going to talk about today, but an email might suffice for that
That's
type
right.
of agreement. Great, thanks.
You want the fundamentals to at least be in writing. And we'll talk about what those are too.
Great.
So we mentioned contract templates and what should your contract template address, right? Contracts do a couple things. They focus on the current state. So what is who you are right now, what's happening at the time of signing, and these are called representations. So you might hear lawyers or whoever's working on the contract say, what are the reps, right? The representations within the contract, meaning what are they stating as of today being the date of signing. So your contract template should really lay out very clearly each party being able to state their current state. Future state, what will happen tomorrow within the grant term, if we're talking about a grant agreement, or within the service agreement term, if we're talking about a service agreement or a contract. What will happen in the go forward? Those are warranties. What are you saying or warranting that you will do or will not do in the future? So it really is covering what is and then what will be. And that's what your contract templates really should be setting out to do.
Great.
And we'll talk about good templates and not so good templates, but that's essentially what your template should be trying to cover.
Yeah, so there's a question right now that we can put it on hold for later if you want, but I'll just read how they wrote it. This is a timely conversation. We're a funder who provides a lot of general operating support to our grantees. We also seek to provide targeted capacity building support through consultants that we have identified, many of which are for-profit. So we're trying to figure out the best way to structure those agreements. Do we give the grantee additional restricted funds to work with the consultant we identified? Do we contract directly with the consultant to provide services to the nonprofit? What are the things to think about in that kind of scenario? And again, just want to make it clear, this isn't specific legal advice, it's just a scenario.
Yeah. No, it's a really good question, and it comes up a lot because you then think about the parties to the contract, right? So if we take the situation where you are essentially engaging the consultant on behalf of the grantee, the contract is with you, right? And so there are some considerations there where you would say, okay, well, is it actually the foundation, for example, the Grantmakers project, and that's why they're engaging the consultant directly, which would make sense. But in this case, it's like, well, it could be because we have this capacity building project, and as part of that, we're helping out organizations that need capacity building support. So I've definitely seen it done that way, where when you think about the values, you don't necessarily want to interject yourself into that relationship in that way. Often, what you want instead is just to say, look, we want to fund this the easiest way possible. And so you've entered into the contract with the consultant. What you can also do is make sure that you build into that agreement who should be notified, who should also receive reports, who should also be included in the conversation when you are contracting that consultant. And that would be the grantee organization as well. So there's that way to do it, but there's also just, this is your decision. You can go out and find the consultant. We obviously will serve as a resource, we'll help you, but this is your grant and that's for capacity building. And then the grantee can come back to you and say, hey, do you have any recommendations? They can go to their partners and colleagues and say, do you have recommendations? But that contract will then clearly be between the grantee and the consultant. And that is a very clean relationship where the grantee is engaging the consultant directly, maybe they will then let you know that this has happened because you've awarded grant funds for capacity building. So they should report back and say, hey, we made this kind of progress, here's what's happening. And so the second type of engagement is a lot cleaner. And sometimes it can just be about efficiency and an administrative approach when you're trying to do the former. But if you really want the grantee to have full control over who they're selecting, why they're selecting them, and really be the partner in that contractual relationship with the consultant, then giving the grant to the grantee can make sense. But I also know there's a lot of things that go on internally, internal policies as well, that might impact you having to, do the first one.
Great. Renee, you're going to move on to the representations and warranties.
Yes. So yes. So again, that's what a contract template does: current state, future state. When we're talking about, we talked about these two rooms, right? The values room, so to speak, and the legal agreement room. We have to get into just specifics of contracts. What is a contract, the bare necessities, and some of the considerations that come up in that space in order to see how we can then infuse the values into the relationship, right? Or into that contract. So you can go to the next slide. Okay, so we have to talk through, what we consider the bare necessities, like these fundamentals: who, what, where, when, and how much. And again, these are parts of the contract where I think a lot of us are comfortable saying, oh, we definitely know that part. These are the things that change usually with each engagement that you have. But I want us to think about how we can make sure that our values are showing up even within these very basic provisions, right? Where we just sort of take them for granted and say, yep, we know this, and we move on, we enter the information and move on. But I think it's an opportunity for us to think about how can we make sure that our values are showing up in that space as well. We pulled out IP, or intellectual property, because again, it's so key. We're talking about ownership. We're talking about use of the work product, the things that are coming out of this funding, who gets to use what and when. This is really where, this power dynamic that we talk about within the sector usually comes to play, right? And it also is very analogous to the same sort of power dynamic you would see in many other sectors or industries, where you have someone paying for the service in the context of a service agreement, and you have somebody who's funding a grant award, being seen as the person who has more of that, quote, power in that dynamic, right? And so it then lessens the ability of the other party to really fully negotiate on their own behalf. So just being cognizant of that kind of dynamic and how you are contributing to it or how you are stepping away from it as we talk about contracting really does come up when we're considering IP provisions. And then the last thing we wanted to pull out was standard provisions, or what people call boilerplate language, right, within the agreements, which are the indemnification clauses, the confidentiality clauses, how we're going to resolve disputes. These are the kinds of provisions that show up in pretty much every service agreement, and sometimes in grant agreements, depending on the type of grant.
But those are the provisions probably that the question around when we don't care about, we care about the outcome, but there's no real recourse if something doesn't happen. Presumably those, particularly indemnification and dispute resolution, might not be addressed. Confidentiality probably would be, but the other ones would not. Is that accurate?
Right. If you're saying like we don't have a written agreement, we've just agreed to this verbally. Well, why should they keep it confidential? Because you verbally agreed to it? Why should, if something happens with indemnification, we'll talk about what that is and why you should really pay attention to it. Why should they then say, well, we'll pay that claim on your behalf because, right. So all of those kinds of questions, I think you're exactly right, that these things don't show up because you haven't protected yourself or your organization from these kinds of situations happening. And we talk a lot about how we're showing up as values-based organizations and in contracting. But you also have to remember that you are a steward of charitable assets when you're sitting within your organization. So you have a duty, a responsibility to make sure that you are spending these charitable assets appropriately and that you're protecting them in a good way. And that means that when you're entering into agreements, you have agreements that are tailored to the actual situation, right? It's a risk management and a risk analysis that's happening each and every time.
So if we're talking about, for example, strategic partnerships where people might not be able to foresee any situation where there would be indemnification required or a formal dispute resolution process, there's no money involved, it's just an agreement about what they're planning on doing. And let's say they do have an email agreement, it's not a formal contract with parties and all of that. What would you say to them in terms of the need to have an indemnification provision? Like, is that necessary in that kind of agreement where there is no money at risk? There's likely the most that might be at risk is perhaps client lists or contact lists or something along those lines.
Right. I think that it depends. It could be that you have an indemnification provision within the partnership agreement, but it's not as extensive as an indemnification provision where you have lots of IP at play. There's a ton of operational risk. You're going out there might be data privacy issues. So there definitely, you want to tailor it to the situation, but I wouldn't go in there and say, well, we're not exchanging money, but if, for example, we mentioned client lists, like if that somehow gets disclosed and there's any sort of negative consequence from that disclosure, or it somehow rises to the level where someone says, I'm going to sue you because you disclosed this information, but it actually wasn't you. It was someone acting as part of that partnership. You want to make sure you understand who is indemnifying, who is that in that case? Is there indemnification at all? Are you limited in terms of indemnification? Up to what amount do you have to indemnify someone for, right? So I think even though money is not exchanged, there might be reports that are being produced. Who owns those reports? How can they be used? So lots of different scenarios can come up. And I don't think it hurts to have, when we say confidentiality provisions, again, this is back to the tailoring, you could have a couple of sentences, right, that really get to what you mean when you talk about confidential information and how you want each party to receive it, store it, and manage it.
Thanks.
Okay, so we're stepping into the who. And, again, this is a part of the agreement we're very clear on. We know, okay, we're entering into an agreement. We know who the parties are. We do have to ask, are they individuals or are they entities? That can then impact the language that shows up in your template. And sometimes it should, because, you want certain protections from other entities that you may not require from individuals, and vice versa. And it's also important, like, are you actually engaging with a party to the agreement? Sometimes organizations have DBAs, right? Doing business as names, and it may not actually be, or just a marketing term to describe all of the organizations within their ecosystem. And there's not an actual entity there. And so you want to make sure that when you are engaging with another organization, individual, that you're actually engaging and putting the name of the legal name of the party into the contract. Because when we start to think about, okay, well, what happens if there's a breach? What happens if something goes wrong? It's harder to say, now I actually entered into the agreement with this legal entity when you have another party's name, or, an actual DBA or not a real entity in the other party, as the other party. So you want to be very clear about who is actually entering into the agreement. And this is also on the Grantmakers side. We use DBAs sometimes, we use other entities for different purposes within the ecosystem, and just being clear and letting the grantee know, letting the partner that you're engaging know, this is the entity that we use for contracting, but it's part of this larger ecosystem that we have. Again, one sentence, two sentence explanation. Why would you do that? because this is part of relationship building, right? If they have been building a relationship with one entity and another shows up in the contracting, it's not like they're not going to engage in the contract, but you still want to make sure that they're clear as to why this party is showing up in the contract. So just being very clear on that, also on who's doing what and who's performing the work or services, who, when you're talking particularly in the context of a service agreement, being clear on who exactly should be performing that work, who will be reporting back to who within the organization, and making sure that you have the right points of contact in that space, right? So often what we see is you'll have, any questions about this agreement, reach out to the CEO. That we know that's probably not going to happen, right? If the point of contact for a freelancer who's entered into a contract with a grant maker, and if they have questions, they're not going to likely reach out to the CEO. They're going to reach out to their contact within the organization. So again, this is where you think about your template, but also think, okay, should this actually be the right point of contact? Because if you're doing things outside of what the agreement requires, even at the points of contact, you are not actually in compliance with your own agreement.
Great.
Okay, so then we're moving into the what. And this is talking about, the services or the work that's being done and the deliverables that are coming out of it. The first thing that we want to say is that it has to be for charitable purposes, right? So whatever you're doing, if you're making a grant, you're engaging a consultant, has to be for charitable purposes. So when you describe what's happening within the agreement, you should be very clear about what you're doing and making sure that that work, that activity is in fact charitable. What we see is a lot of vague descriptions because the folks that are writing the description are very steeped in the work. They've seen this, they've had many conversations with the grantee, let's say, or with the consultant if they're engaging them through a service agreement. And both parties involved are very familiar with the work. So when they see something like to support the capacity of the health campaign, everyone's on the same page, right? They have the scope of work in the back, the proposal, they have enough dialogue between them to say, we know exactly what you need. But others, anybody else coming into that might not know, right? It's not clear from its face that this is actually charitable. What we'd like to see instead is this example that we have as a statement of work or the purpose that's clear, which is to build the capacity of nonprofit coalition members, strengthening public health systems throughout the rural South. On its face, it's charitable. On its face, it's describing very clearly what is happening, the purpose of the agreement, and that's the kind of language and clarity that we like to see when we're talking about services or the work being done.
So there's clarity of the purpose, and then there's clarity around the actual asks and obligations and expectations.
That's
so
right.
2 levels.
That's exactly right.
And we also have 2 questions. I think you're going to talk a little bit more about what, but we have 2 questions around things that are appropriate or inappropriate in agreements.
Mm-hmm.
The first one of our participants said that they have seen NGOs demand unlimited indemnification from independent consultants, quote unquote, for any act. Is in terms of trust building, the commenter said that they find this abusive. What is your thought on that?
So I think it's a really good call out, and I like the fact that we're talking about indemnification because again, it is a provision that I think many of us skip over or don't pay as much attention to. Yes, I think when you talk about indemnification, again, if you're looking at it in terms of relationship building, you're saying up until the contract, we're in this together, we're partners, we want to make sure that we're clear on who's doing what and expectations, and then you get to the agreement, and it's one-sided, it's unilateral, as we say, right, for indemnification, and you're indemnifying them. They being the consultant or the grantee is indemnifying you, and you have no indemnification responsibilities whatsoever. It's not, it doesn't align with the messaging that you have been sharing with that partner, right? So when we're talking about building trust and continuing to build that relationship, at that point, you can see a lot of I don't say a lot, but it happens quite frequently where that's where negotiations or proposed engagements break down at the contracting phase, right? So you're all in agreement and you get to this legal template, templated contract, and it's like, well, you don't know necessarily what you can negotiate. You just share the template, which is not reflective of your organizational values. It has this indemnification provision within it, and I would think it probably has others within it if that is just one example of the standard language that they're using. And so I think that that's when you start to have harder conversations within that relationship. So I think there's many ways to do indemnification. We'll talk about that in more detail. There's lots of different iterations of how you can indemnify someone or be indemnified. Again, we understand you are stewards of your charitable assets, so you have a responsibility as well to make sure that you are protecting those assets. So there's a good way to get to that point where you're both feeling, you're stepping into that relationship saying, we're going to be fair. All right, we're going to be fair. So I think that's an indemnification piece. I think, again, this is when it's a great time to revisit your templates, right? And look at what your indemnification language says, because sometimes it's just unnecessary. But again, it's a template that everyone has been using and no one has questioned.
So we have another one on that trust, on the trust question. One of our participants has a commitment to engage vendors who come from communities that have experienced marginalization and violence. So they are considering offering a one-pager to every vendor they engage that walks them through some of the basics of engaging in a relationship with them. And some of the things that would be included on that is use of pronouns, respect for people's gender and racial identities. And the question is whether they can add that language to the contracts or whether there would be any issue with doing that.
So I really, really like this approach. I think that the one pager is very helpful. The question is, would you gain anything else by adding it to the contract? The contract is an agreement, right? So if you're saying within that within the language, here's what we are agreeing to, and here's how we would like you to engage with others, engage with us. Here's what we want you to do. So back to this contract template of, it's all about representations and warranties. Current state, future state. So what are you doing and what do we want you to do? So if you're asking for agreement, then yes, I would say put it into the contract because it's something that you want them to agree to, or something that you're saying that you will agree to, right? So this is how I will engage with you. If it's any language like that, then I think adding it to the agreement would be added value. I think if it's just, we just want to let you know that this contract is part of our relationship building. And as a result, we're trying to take away some of that legalese. We're trying to make sure that we are, showing up the way that we have shown up from the beginning of this relationship. Then I would say having this one pager is entirely appropriate. So all of that to say, if you want an agreement, then you would put it into the contract, but I don't think it lessens its value or its impact by keeping it as a separate one pager.
Yeah, so I know, I suspect that many organizations over the past few years have been reevaluating and reconsidering their values. I know we are as an organization as well. And one of the biggest questions is, how do we live our values? So I almost feel like having that be a part of the contract, including what actions will be taken as a result of those values, could be pretty significant for relationships and for alignment.
Great. So when we're talking about the what, again, we laid out it has to be for a charitable purpose. And we'd also started to say the reason for this is, and being clear about it, is to avoid project creep, right? And this is important because one, you're making sure that what you have agreed to is actually what is happening. And then two, that you're being fair and just, right? You are actually paying people for their labor. We talk about that a lot in this sector. So if you are agreeing to do A, and then you're asking this person to do A, B, and C because you don't think B and C is that significant and you don't need to add it to the contract, now you're having that person do extra work and you're not compensating them for it, right? So think about, this is the reason, again, back to values plus the legal fundamentals, the reason that we want the clarity, yes, for charitability, for tax purposes, but we also want it because we're thinking about our own organizational values and the way we want to show up, and having someone do extra work and not have it reflected or being compensated is not what our organizational values are supporting. So we also talked about amendments at the very beginning, and we said we want them to be written. You remember at the start of the pandemic, we had a lot of amendments happening for project support grants that were being converted to general support grants. And a lot of grantees we had conversations with said, yeah, the grant is being converted, and well, where's the amendment? Oh, it was over the phone, right? And so then it took months after that for that conversion to happen, for the additional funds to come through. And they had grantee organizations just waiting, right? Because what is your recourse? I had a conversation with a program officer who told me that this might happen, this should happen. So this is when we're talking about, even with amendments, and it's not about not trusting, it's about making sure that whatever you have agreed to is sitting in writing, and all parties involved are clear on, okay, we've agreed to convert this grant, for example, and we're going to do it by this date. And just, again, having that clarity about the what, and having that in writing. Pulling out any exclusions, things that should not be within the scope of work or the deliverables, and being very clear, particularly when you would assume that those things would be in there, but saying, actually, no, this is pulled out. So we want to make sure that all of those exclusions are sitting in the agreement as well. You want to talk about whether specific deliverables will be provided. Again, we see this a lot where, a report might be sitting in the written agreement, but then it's like, oh, can you also provide some email status updates, or status updates via email? And so now you have additional things happening outside of the contract. So we want to be clear on what are the specific deliverables. And then finally, this is all laying out what are each party's responsibility, right? What are they committing to do, right? And so this part of this what is also saying, should you actually be entering into a grant relationship or grant agreement with this organization, or should it actually be a service agreement? When you start to think about the deliverables and how much, how often you're going to check in and what this relationship is looking like, think very carefully about, should this actually be a grant as a result, or should it be a contract? And this is the space where those questions would come up.
Great. So we have about 15 minutes to cover the when, where, how much, and intellectual property.
Okay, so we'll highlight these just in the interest of time. And please feel free to continue asking questions. We can always follow up afterwards as well. So the when is very important. This is about trust. I think this is a space where we want to be very clear and realistic about deadlines. So when you're saying this has to be done by June 1st, think about, like, does it actually have to be done by that point? What capacity would your partner need to actually complete it? And so thinking about those things, bringing in your organizational values, and then saying very clearly in the agreement, here is the true deadline, right? We'd love it by June 1st, but actually we don't need it until July. So just being very realistic about that. So knowing the delivery dates, the term is just the beginning of it until it ends, and then termination. When can a party terminate before the term end? Like under what circumstances is that allowed?
So would you recommend that parties build into an agreement at the outset a process for adjusting deadlines? Because sometimes with the different power dynamic, people agree to deadlines that they're not sure they can make, and it might end up being quite a bit of work to make those amendments. So is that something you'd recommend building in at the beginning?
Oh, yes, definitely. So I think, like, even putting it into the template and saying, hey, if these deadlines need to shift, here's the process for shifting them, so that you're not going through this elaborate process of, getting both signatures, and it has to be hard copy, whatever requirements, but just saying, just letting someone know, or if it's beyond this particular date, you don't have to do an amendment. You can say all of that within your template. And it makes sense when you look at why you're amending your agreements. If you're seeing that it's always because of deadlines, I think it's one, having that internal conversation around just having realistic deadlines, but it's also that second conversation around, okay, well, how can we adjust for this so that we can, again, we're not causing administrative burden on either side, and we can say like, look, this is how an amendment will work.
Great.
Okay. So where, it's very important to understand where the person will be delivering the services or performing the services. And that's because it has both tax implications in terms of, if you're in a service agreement, you have someone working in the United States versus outside of the United States. The tax reporting that comes from that and the information that you need from that partner is very different based on where they are located. And it also has labor implications. So if you have, again, you've engaged a consultant via service agreement, and you have the person sitting in your office at a desk with a business card and a telephone, these things can then transform that relationship from consultant to employee. So it may have labor implications as well. And this is where, again, you see that that conversation coming together of values and legal considerations, because usually you want the work to be done exactly where the issues are showing up, or where you are problem solving alongside the communities that you're serving. That helps with program credibility. It also makes sure that you're not having this top down type of approach. So that means you might be working outside of the United States, and you also want to then think about, what are the local laws that they have to comply with? When should you know about local law compliance? And your template can do those things and can pull all of that in, all of those warranties, right? Like what they can do in the future into that agreement, so that you're not thinking about it, but being very clear about where the work is being performed is very important.
Yeah, and I just want to call out that for global grant making, which will be covered in our third webinar, there are some very specific considerations. So if you haven't already signed up for that webinar, we can make sure to let everyone know about that one in the post webinar email.
Perfect. Okay, so we're talking how much. And again, this is about the fee or the award. And you might see this provision and say, oh, well, yeah, I know the amount. Here's how it's going to be paid. But here's, again, a really good place where values meets the legal considerations, or just the practicalities of the situation. When you set the fee award, is it fair? Right? Is it actually compensating folks for the labor that they're performing? Are you giving them the flexible type of support that they need, right? If we're talking about a grant context. And how will payment work? Will it be flat fee, by the day? All of these different questions come up because you're thinking of how to pay. What I've seen some organizations do is they think about, well, our finance team said that we can pay this way, and so this is how our template reads. This is how we pay out grants. And it happens in every single grant, same thing over and over again. And it might work maybe for certain grant makers who have very similar grantees doing very similar work. But when you're thinking about who's on the other side of that conversation, who's in that relationship with you, and considering, are you working with a small or micro business? Are you working with a community-based grassroots organization that might need the funds at different times? And so if you have a net 90 or net 120 payout or payment term. So you're not paying until it's 120 days after the work is performed, and the contract is for 5 months, and you're dealing with a micro business. Think about the impact that may have on that business waiting for 8 months for payment. And you're then saying, well, part of our organizational values is economic inclusion and opportunity, right? So particularly for small businesses. So if you're saying that that's your organizational value, how is that then showing up in the way you're paying and how you're paying your partners?
And also, there's the issue of the right amount of ask for the amount given with respect to grant relationships, right? So asking too much in terms of reporting based on the amount that you're awarding. So being very cognizant of that as a trusted partner.
Agreed. Agreed. I see this come up a lot. And again, we'll talk about a lot of these implications when we have the webinar you just shared, Renee, on international grant making. But when you're thinking about grant making in the international context, and there is some flexibility about requiring bank accounts when you're making grants to certain organizations, you want to consider, is this the kind of organization where getting a bank account will be administratively burdensome for them if we're awarding $1,000 grant, right? So definitely, I think it's something you have to keep in mind.
So there is a question, it's pretty specific, around the risks for partners when you seek low costs via a long-term firm fixed price contract, then add termination clauses of exits by the funder for 30 or 60 days. And then there's a note that this significantly alters the cost of work, the cost for work delivered, particularly for small organizations. So do you recommend T&M instead?
So I think it depends, and it probably is a longer conversation with the partner involved to understand how do they want to be paid. Sometimes when you see a fixed rate, it's based on time and materials plus some other factor that they've included. So if that's the case, I think raising the rate question I think it's such a values-based approach, because otherwise you would say, well, we've got the lowest number here, let's go do it. But instead you're saying our organizational values are going to require us to have this conversation about how will this work? This doesn't seem market where you are actually substantially below. What would it look like if we increase that fee? Because would that give you additional capacity to perform within the terms of the engagement? So I think raising the question, having the conversation is absolutely a values-based approach. I would not suggest someone, change the way that they're working if they believe it is working for them. But I would raise the issue around if you are well below market, because we're seeing lots of contracts come in. And so you have a vantage point of saying, well, for this kind of work, we're paying, this range, and you are, exponentially below that. I think that is absolutely something you raise and have a conversation about to make sure that it's fair throughout the course of the relationship.
Great. So we have 5 minutes. We don't have any other questions right now. So we can go through, hit the highlights of the rest of the presentation.
All right, so I'll hit the highlight with IP. So IP is really important. I'm sure this is the piece where consultants come back and ask questions. If it's in the service agreement context, grantees might be raising questions depending on your template. And so you can have deliverables or work product can be considered intellectual property. So you need to think about who will own, who will have the license to use that property. Their default IP provisions within agreements, which are one in the grant agreement, usually have the grantee own the deliverable and the grant maker receives a license. This is subject to other interests that might be at play here, but that's really the default position. So if you are owning the IP that's coming out of grant agreements, revisit your template and really think about why you are doing that. Service agreements, the consultant usually creates work made for hire, and then the grant maker owns that. There could be instances where you license, and on the next slide, we'll talk about the questions. We can move to the next slide. So these are the questions that then impact those default positions. Right? So I'm not going to run through all of them here, but these are the questions you want to ask yourself each and every time you enter into an engagement. Even if you have a template that you're working from, you should still ask yourself, should this actually fall into our templated language? And your template language should be flexible enough to accommodate different scenarios as well. But it's really important that you start from a position of, we want to be fair, We also recognize we're charitable stewards, but we are entering into a relationship with you as well. So default positions of we own everything, you own nothing may not actually work or be aligned with your values. And so here with the standard provisions, we actually talked a lot about indemnification, and we just wanted to call out these different bullets here because there's lots of ways you can do indemnification. It can be very simple, or it can be pages and pages long, right? It can be mutual where you're both indemnifying each other. And I don't see that as a bad position to take at all. I would consider, well, why don't you want to indemnify, right? You can also put limits on indemnification. My point here is that there's so many different ways to do this that you want to make sure that you are reviewing your indemnification provisions and that they're appropriate for the engagement that's happening. What I'll flag about confidentiality is we need to make sure that it's practical, right? So what I see a lot is everything is confidential. Every single thing that we talk about within this arrangement or it will be confidential. And so it will be marked as such. Or, you know, if you don't mark it as confidential, then we won't treat it that way. So you have to think about how those requirements then play out and are they actually practical? And then dispute resolution, where, you know, what happens if things don't go according to plan? Where will this dispute resolution take place is another really interesting conversation to have, and being flexible on governing law, particularly when the law is in the default state of the organization that's funding the work. So there are two tips I wanted to point out here, and one we've talked about before, which is the bottom tip, which is consider adding provisions that are reflective of your values into the contract, right? So if anti-bullying is very important to you, put it into your contract and require that whoever engages with you cannot maintain that kind of environment where they work. And don't rely on just the boilerplate. Make sure that you're digging in and make sure that you can make it reflective of the relationship that you're building.
That goes right back to some of the points raised earlier. Great.
Mm-hmm.
And now I think we have some do's and don'ts to wrap up with.
Yes. So to wrap it all up, definitely enter into written agreements, contracts that are reflective of the agreement that you have made verbally with each other or with other partners. Review your templates. If anything, once you leave here, if you don't have a template, this is a great opportunity to create one. And if you already have a template, an even better opportunity to think about how you can switch things up and change it to make sure that it's reflective of your organizational values. Be realistic about your expectations for yourself as well as other partners that you're engaging. Talk about your IP. Make sure that the ownership and use are aligned with your organizational values, and consider contracts as relationship builders. They are not just legal agreements that you sort of push on other folks to sign. They are part of your relationship building. Definitely don't use a one-size-fits-all approach, and we've talked about that at length. Don't rely on verbal agreements or confirmations. If it's important enough to talk about, it's important enough to put in writing. Don't treat your consultants like employees or your grantees like consultants, right? Be clear on how you're engaging each partner. And then finally, don't inadvertently strengthen an unhealthy power dynamic through your contract language or the way you negotiate that contract. This is part of your relationship building, and your contract is just another piece of that relationship. And that's it. So thank you all so much for your
with that,
attention.
we just to follow up, thank you, Nick, so much. This was a great webinar, great questions. We had several other questions that we didn't get to, unfortunately, but we will definitely do some follow-up after, which will include the presentation and also a survey that we'd love for you to answer, where we ask what other topics you'd like to hear about, or even some of these topics that we talked about today that you'd like to get more in depth on. And if you want to sign up for Nick's newsletter or podcast, her email address is there. The podcast, Nonprofit Buildup, is available wherever you get your podcast. It's a weekly thing. And for more information on RPA, please email us, info@rockpa.org. And we thank you all for coming. Again, we will send out the presentation as well as some follow-up information. And thank you, Nick.
Thank you.